Blog Talk Radio.
Welcome to the AME Food Testing Show. Today's topic, responding to FDA warning letters after FSMA, with Marc Sanchez, Esquire. Marc is a lawyer. He also has a master's degree in international communications policy. He's an attorney and consultant with social media, privacy, food, FSMA compliance, recalls, USDA imports, FDA, and CPSC compliance issues. Marc's practice is in Atlanta, Georgia. He focuses on product recalls, regulatory compliance, and employment law. He has a special interest and knowledge of food law and social media, privacy, publishing several articles, and presenting throughout Washington on the topics, including FDA compliance, food and medical device recalls, import protocols, and employee privacy. Now, welcome with me, Marc Sanchez, lawyer and attorney for food clients. Marc?
Andy, thank you for having me.
Marc, you are a welcome guest. And as I invited you in our last conversation, as things are now starting to solidify with the FDA and the newly enacted Food Safety Modernization Act, we're starting to get some strong messages. Let's talk today about one of those messages, is what is an FDA warning letter?
Well, this is a great question, and, my practice is really focused on representing the Food and Drug Cosmetic Act regulated industries, dietary supplement, food, anywhere the FDA goes, and anywhere the FDA goes, they can issue a warning letter. And the warning letter is jumping on to about midway of the story. And so if we go back to the beginning, we can kind of understand what a warning letter is. And a warning letter arises out of what's called a Form 483. And a Form 483 is an inspectional observation form out of the inspection manual for the investigators that the FDA has. And Form 483s arise out of an inspection of a facility. And that can happen either because of an annual routine inspection that will occur, or it can happen because you have a product issue, a recall, an outbreak, maybe a misbranding or a labeling issue that has gotten the FDA's attention, and now they're coming into your facility, and they're either coming to look at the specific issue or they're coming to look generally at your facility. Now, once they do this, the investigator will write down the observations that they made while in your facility. This is just the investigator's opinion on what are potential violations of the Food, Drug, and Cosmetic Act. And they provide this along with the establishment inspection report to the compliance officer that will be assigned to the case. And that officer makes a determination on whether or not to issue a warning letter. Now, sometimes the warning letters are issued because the violations on their face are very serious. I've seen cases where the 483 will notice pests or maybe employees aren't following sanitation protocols, product adulteration or misbranding. Things that are on their face are serious violations that warrant attention, and there will be a warning letter issued with it, regardless of the response. But in most cases, what I often see, and it's very rare that I get involved at the 483 stage unless I'm involved in the recall, because as part of the recall you will be investigated. But oftentimes I get in after a client has responded to a 483, tried responding to a warning letter, and then finally gives up and looks for an expert in this area and will come to me. And that's one of the ways that a warning letter will be issued. 483 is pretty common observation, but the response is so bad that the FDA just gets the sense that you don't get what's going on, and because of that, these very common observations won't be resolved. So the warning letter is issued because of the response. So that's the two ways that you can typically get a warning letter. And from the warning letter, it's very imperative to resolve it at that phase. It's sort of the line in the sand for the FDA. And if you don't resolve the warning letter, it gives the FDA a paper trail, a sort of record to say, you've been warned, and now we're going to take either civil or criminal or other action. And we can talk more about that because the civil side, FSMA has really given the FDA some teeth on what they can do.
Marc, that's an excellent explanation about what is an FDA warning letter. When is a warning letter issued? You alluded to it earlier, after there's been a record of incidents that the inspector has found.
So typically what we see is that the 43 will be issued almost immediately after the inspection. At the most, a day to 2 days, you'll get the 43. The 43 requires or allows, it's actually not a requirement for a response. A response is always recommended, but only, I always tell clients, if you're going to give a response, make sure it's the right response because you don't want to muddy the waters. But the FDA allows 15 days to respond and then an additional 15 days for the compliance officer to look at the 43, the establishment inspection report, and the response that's provided to make a determination. So typically we'll see warning letters issued after 30 days, depending on how long that review takes by the compliance officer. And sometimes those warning letters come a little faster just because we see something that is so serious that the FDA doesn't need a lot of time to evaluate or to look at it. And this also gets into the question about photos being taken in the facility. This is becoming a very common practice, and there may be something in those photos that gets the attention of the FDA, and that will happen a little bit faster. But at the most of the time, we'll see it after the 43 response. Within 30 to 60 days, we'll see a warning letter issued.
Mark, that's an excellent summary, again, of the procedure. We've recently seen in the food safety regulatory market some documentation that is following some of the recent outbreaks. In that result, the actual FDA warning letters are now being published. What are the effects of the proposed FSMA regulations on the issuance of these FDA warning letters?
So there's been a few ways in which we're seeing that the Food Safety Modernization Act has immediately impacted warning letters, and then there's some ways that we can see how FSMA is going to, we can forecast and predict how FSMA will impact warning letters going ahead as we get more material. What we can say now of what FSMA is doing to warning letters is a couple of things. Number one, we're seeing that reinspection fees are going into effect, and there's a boilerplate paragraph that's now added to warning letters saying that if the FDA has to do a reinspection, there will be reinspection fees. And that's new. The FDA didn't have that authority to charge those fees previously, and now they do, and we're seeing that in the warning letters. Some of the other ways that we're seeing FSMA directly impact warning letters is we're seeing this new designation of high-risk facility as well as high-risk foods, but in particular high-risk facilities will receive a notification that will be the designation they'll receive, and they will be on an inspection cycle that is quicker than the average inspection cycle. I think right now annual inspections occur every 3 to 4 years, and then under the high-risk food facility, that'll change to about every 2 years. So there's an impact in terms of how often you'll be inspected, which can be burdensome. We're also seeing with FSMA that there is some new teeth to what the FDA can do if the warning letter isn't taken seriously. And that's sort of the point where you don't want to get to. And the FDA has been eager to use those new powers. And we've seen administrative detention of food. There's a lower threshold for that can occur now. Facility suspension, we've seen that occur. Mandatory recalls. We've seen a number of ways that the FDA has actually got some teeth to the provisions that they have. And the warning letter is the FDA's last sort of warning, the last sort of fire across the bow to let you know that those effects may be coming.
Well, Mark, you practice in this area daily. Maybe without revealing any of your specific clients, you can talk in generalities up to our audience of food production, food quality, food safety, and food security managers. What were some of the strategies in the event that things have kind of gotten out of control and they've received a 483 letter?
You know, what I like to call this is the responses to avoid. And a lot of times once I get into a situation, with a recall, and we know that an investigation is going to happen, it's just part of the course for a recall. Or with existing clients, I give them a little bit of a lecture on the responses to avoid if they do get a 43, because 43s are part of the nature of the food industry, and they're increasing in the amount that they're given, and FSMA is only going to see that. So one of the responses that I tell my clients to avoid is the three stooges sort of approach, the approach that compliance officers often talk about. Is just when you read it, you get the sense that someone doesn't really understand what's going on. And to give you an example, I have a client here in Georgia that received a 483 and botched the response, and because of the botched response, received a warning letter. And the reason that happened is that the inspection that occurred, most of the observations were very common, but one of the inspections that they found was that the product had misbranded packaging and had the country of origin listed incorrectly. So the FDA, in its mind, wanted to be able to have have sort of a CAPA analysis, the corrective and preventative action analysis, to see how did this occur, how long had it been overlooked, and what were you going to do to prevent it from occurring again. But instead, the client just immediately fired off a response, I think within 3 days of receiving the 483, and said, more or less, if you were to summarize the letter, it said, yeah, we got it, it's fixed, it's not going to happen again, please close out the 483. And the FDA, reading that, it just came across as, you don't really have a grasp of what's happening in your facility, you don't really have a grasp of the regulations, and because you don't get it, we're nervous of what else is happening in this facility, and so we're going to open the net a little wider. We're going to have you provide more demonstration of compliance to the warning letter. So that's one of the responses I see that I advise clients. It's really imperative that you'll save a lot of money if you can bring an expert in, someone that's familiar with the food regulations, maybe even knows the regional office, has worked with the FDA, and can smooth out that 483 response and make you look really good and give you the sense that, which is probably more close to the truth, that you actually know what's going on in your facility. One of the other big responses I see is the anger response. I have a client that is in the Southeast as well, and they're on their second warning letter, and finally have called me to intervene. And there's this concept that I've been talking about on my blog, and I'm talking about with my clients, called regulatory capital. We hear it a lot in the political sphere where we have political capital. Once you win an election, you sort of have built this amount of political capital that you can spend in pushing different legislation. Well, as a food facility, you only have so much regulatory capital, and that regulatory capital is your credibility, is the sort of assumption that the FDA has that you're a good facility, that you're compliant, that you get what you're doing, and that these 43 observations are really just common mistakes and just little oversight. But when you get into anger response, you lose that regulatory capital, and you immediately make sort of an enemy of the regional office, of the investigator that's trying to work with you, of the compliance officer that's overseeing your case. And you create sort of a hostility, a frigidness, you lose that comedy and that cooperation. And, I've seen this before. This client that I mentioned initially received the 483, fired off a response that just talked about how the FDA was overreaching, that it was unconstitutional, there were some labeling issues, and they got into free speech. Not to say that any of this thing is right or wrong or it shouldn't be said, but the tone and tenor of the letter just wasn't appropriate. And it's interesting to see because when I look at the chain of responses, the response back to the client was almost pro forma from the other one, basically saying, we received your response, but you still haven't addressed these areas because the FDA, it has a job to do. The compliance officer isn't going to care about the constitutionality of the argument. They're not going to care about whether or not it made your day or not. They're there to do their job. And so you're just wasting that regulatory capital that you have if you're firing off the longest response. And that leads me to my last sort of strategy. If you're going to challenge the legality of what the FDA is doing, if you're going to challenge an observation, and it's not to say that every investigator that comes in has the right observation or understood the right component, just make sure you're doing it in a way that is really rooted either in the Code of Federal Regulations, rooted in the Food, Drug, and Cosmetic Act, and if you need to, even root it in guidance documents. Spend the time, and this is where an expert really comes in handy. They're either familiar with guidance documents or they can spend the time researching. And, the investigators that come in don't always know the law. They may be new to the food segment. It's not uncommon to have investigators that will switch segments that they work on. You'll have someone that's worked in medical device now come to food, and the regulations that apply to medical device don't apply to food, and so there may be some confusion. There may be some misinterpretation of the guidance documents. I'm working on a warning letter response now, and it's with the distinction of whether a liquid product fits into a conventional food product or fits into a functional food, a dietary supplement product. And it really comes down to how you read the guidance document on distinguishing liquid conventional foods from liquid functional foods. The investigator has one opinion, I'm formulating a second opinion, and we need to be advocates and persuasive in getting the compliance officer on our side, not the other side. So there are ways to legally challenge some of the observations that are coming in, and there are also ways to just challenge the observations that are made. Not that every observation can be challenged, but I think that's generally the responses to avoid and sort of the strategy I can best give. Be on time, be calm, be reasoned, be very detailed, and if you're going to do any challenges, observations, any legal challenges, make sure you have an expert that can really provide that substantive analysis for you.
Excellent guidance. Let me ask you, where would a lot of these clients generally have turned to, the ones that have made mistakes, in their first instance in responding to a 483?
I see two areas. You see smaller to mid companies where it's a family-run business or it's a closely held company and it's had the same owner or same quality manager for numerous years, and that owner or manager will do the response on their own. And they're basing it off more of their experience, and a lot of times, just given the odds, only about, I think, under 3% of the food facilities are inspected. They may have gone 10 or 15 years without having an inspection and without having a recall, and so they feel that they know what the rules or the laws are. And on the other side, I see more established companies, mid to publicly traded companies that are either new to the food industry through an acquisition or just don't have a full-time food attorney on, and they'll have their corporate attorney conduct that analysis for them. And I think that's where some of the responses go inappropriate or don't really do the job that they're supposed to. The Food, Drug, and Cosmetic Act is its own beast, and I'm happy to tell people when they come to me for a question that's, about another topic, I don't know that area of law. I haven't spent time in that statute. I haven't spent time in those regulations. I haven't been building those relationships. And it's the same thing. If you haven't spent that day-to-day in the Food, Drug, and Cosmetic Act, in the Code of Regulations, you know where to go for all the guidance documents, to know whether or not there's even a guidance document to address. I think that's where the response can go wrong, and it isn't persuasive and it isn't on point.
Excellent, Mark. Let me ask you, do you have any further suggestions for those that are either, as you said, entrenched in their historical methods or those that are new to the industry on the FDA new FSMA regulations and their anticipated impact?
So one of the things I would say is that now more than ever, it's the time to make sure that your 483 response and your warning letter response are on cue. The FDA before would be very slow with civil action, didn't have a lot of weapons in their arsenal in terms of what they could do. That's changed. If you start to build a bad compliance history or you continue to botch 483s and warning letters, it's ultimately going to lead to some serious consequences that weren't available before. I think the other thing that we can start to see is that every year I put together on my website the top 10 observations in each of the categories for food, for dietary supplement, for medical device. And for the past few years, it's been a very stable list. And you can more or less predict, if I have these 10 observations down pat, then when an investigator comes in, more or less I'm going to be fine. There may be a couple of areas where there's just some issues I didn't know and they're not on the top 10 observation list I'm going to miss. What we're starting to see is that you can't really rely anymore on a sort of cheat sheet preventative measures way. And, I never really advocate for clients just to stick to the top 10 observation list, but I tell them at a bare minimum, stick to the top 10 observation list and then go from there. Now with FSMA, we're seeing so many new standards, so many new proposed standards and effective standards coming into play that top 10 observation list isn't necessarily a way to cheat sheet your way into compliance, because there's just so much now that's going to be changing that you really need to take a facility-wide and look at what's happening. Because realize that these investigators are being trained on these different regulations, on these new updates, that's going to be on the forefront of their minds. And so that top 10 observation sheet is going to look very different in a year to 5 years. I would predict that most of what's going to be on that top 10 observation is going to be FSMA-related provisions. And so now, instead of taking a very historical look at what the FDA has done in compliance, I think it's kind of shifting, and we need to take a facility-based view and look at the facility and look at the regulations and see and predict where you're at in compliance and be ready for that as the FDA starts to build that new compliance history.
Excellent, Mark. Your guidance and information has been very helpful. I'd like to now allow you time to explain your practice, the types of clients you accept, and the type of clients that you would like to counsel in the future.
So I represent FDA-regulated industry, typically in food, dietary supplement, and medical device. Occasionally I get a drug client, but that's a really specialized category. And I help clients on either side, pre-market and post-market. And pre-market, if you're getting a new food additive, a new food ingredient, a new dietary supplement ingredient, making sure to proactively get those on the market. Because a lot of times we see warning letters and 483s issued under a new drug designation or generally not generally recognized as safe. So that's one way to sort of preventatively get out of the 483 warning letter. A big part of my practice is helping those in the industry get out of the messes that they get into, either with recalls, outbreaks, mislabeling or other adulteration, misbranding, and the 483s and the warning letters that kind of go with that. So I take clients of all sizes. Doesn't matter if you're a family-owned farm or you're a publicly traded company. I help represent all sizes of companies. And the good thing about my business model is we come on as contract in-house counsel, which allows us to practice nationwide, and we can come on in an economical way on long-term projects, because a lot of times when you get into a stage where you have not responded appropriately to a 43 and not responded appropriately to a warning letter, it can take upwards of a year to get out of that, unwind all of that mess that's created, because by that point you raise the scrutiny of the FDA that they're nitpicking at a lot of things, and it takes a lot of time to get all your ducks in a row and to get all the responses written. So that model allows clients to bring on someone for that longer-term project and have it work out. So that's typically my practice in a nutshell, and now with FSMA I'm seeing more and more FSMA both proactive, making sure clients are understanding the regulations, helping clients comment on the regulations, and starting to see the impact of what FSMA is doing.
Wonderful, Mark. I'd like to now allow you to conclude your remarks and then offer any final advice to our 40,000-plus listeners.
I think my final advice is that a lot of times we get into a mindset, and I see this now with FSMA, that enforcement doesn't happen, that the FDA doesn't have the manpower, doesn't have the boots on the ground to really make it happen, and that I'm going to be one of the lucky ones that doesn't get a 43 or doesn't get a warning letter. But what I've seen in the industry is it doesn't matter how long you've been in or how good your practice is, you're eventually going to get a 43 inspection. So make sure you're ready for it in a proactive way. Make sure you're not gaining extra FDA attention by being proactively good manufacturing practices, so you don't have an adulteration issue, you don't have a recall, you don't have an outbreak that will bring that FDA scrutiny. And whenever you get into a situation where you have FDA attention brought onto you, it's really important to make sure that you're taking the time to respond in a way that doesn't squander that regulatory capital. You're probably going to be in that same regional office for a long time. If you're an established company, you've probably been in that regional office for the entirety of your time there. You want to make sure that your 43 response preserves that relationship and maybe even bolsters that relationship so that the compliance officer and the investigator begin to know you and have that trust in you, so that if the 43 response is resolved and the inspection comes out later, they're coming back to you on good terms and they're not coming back to you with strong memories of what has happened before. So bring an expert on, really find someone that has spent time in the food regulations, and be proactive, especially with FSMA now occurring. Comment on the rules, make sure you understand how the impact is happening, and proactively look at your facility's operation.
Well, Marc, as always, I'd like to thank you for your time today. And as these regulations are finally published, I'd like to invite you to be back on the show and talk about how those regulations are now going to impact the food industry and our food production, food quality, food safety, and food security managers.
Thank you. It's always a pleasure to be with you.
Right. Marc, have a great day, and look forward to hearing from you in the future.
Likewise.